Question on the bill, Representative Wilford Carter.
Wilford Carter.
Do you have any idea, Representative, how long the presumption of causation been in the law?
I think the Housley decision came about in the 90s, so it's been around for a long time.
Right. And if a person was in a car accident, for example.
Almost as long as I've been alive, Judge.
Longer. It certainly was here when I started practicing law in '75. Yeah. That's probably longer you've been alive. But if a person's in a car accident and he gets his back hurt, he claims.
Yes.
And he takes an X-ray, and the doctor really can't find any objective reason for the backache, but he has a very bad backache. And he goes to court, he files a claim saying that his back got hurt in an accident.
Yes.
Never had a back pain before in his life. So he wouldn't be able to use the presumption in that case. So how would he prove that his back was hurt? If the presumption wasn't there, how would he prove his back was hurt?
So, I mean, in that case, the plaintiff would have to prove, I mean, the burden is going to be on him. You're absolutely right.
But he can't prove it if the X-rays doesn't bear him out, but he got pain.
I mean,
and the doctor, there are ways doctors have to determine whether or not you're malingering, if you're really lying about the pain. If you got pain, docs say you got pain, but he cannot prove it came from the accident because there's no objective medical evidence to support that claim. The only way he can prove it is by this presumption. It forces the burden of proof on the defense. And so you taking that away. So our citizens in this state will not have the ability to recover for their injuries because of this presumption will no longer exist. Do you really think that's a good idea?
Well, I think that the citizens of our state are on both sides of that trial. So there's a citizen who's the defendant in that case as well. And I would say also is that it doesn't take away their ability to recover. They just have to prove their damages, just like they have to prove every other part of their case. And so the presumption doesn't get away their ability to recover. It just shifts that burden of proof. And when you have that burden of proof shift, you don't have to prove it, and you don't need objective evidence. And that's the fundamental part of this problem, is that you're allowing people to recover without evidence, without a doctor saying that. And the trier of fact, the jury or the judge, has the ability to interpret all the evidence that you present of their prior medical history, of what the doctor testifies, and they can review that evidence and say, I believe that plaintiff, I believe his injuries, and here is his damages. And so it doesn't eliminate that. It just requires them to prove the elements of their case.
Under current law, if the judge believed the testimony of the claimant and his doctor that he has pain, and he never had pain before this accident, this would be a legitimate recovery. But if this passes, the judge couldn't take that into consideration. And so he would have to have some objective way to prove he was injured, and absent that, he couldn't recover.
That's not correct. It doesn't require him to have absolute objective evidence. It just requires him to have they just have to have evidence. That's all it requires. It just shifts the burden of proof back to the plaintiff like every other element of the case.
Well, how much insurance are we going to save with this bill? What the rate's going to? You got any studies that was done that would show this would reduce insurance rates?
Well, all I can say is that Louisiana has the highest or second highest, and we're the only state that has this. So if we go back to, if you say, hey, it moves us toward the average, then the average would save, every family in Louisiana $1,000 a year. So I can't say it's going to do all of that, but
well, may God help the poor Louisiana citizen. Thank you, sir.
Representative Lacombe for a question.
Representative Nelson, I know you're an attorney. What year you finished law school?
2010.
Since 2010, how many jury trials have you tried or been part of? Absolutely none.
I said I'm an attorney, but I never practiced. That's why I'm up here arguing against the attorneys to recover, I guess.
So you've never tried a jury trial. Have you ever tried a judge trial?
I always said I never practiced. I haven't tried any trial
you've never
ever.
Litigated anything at all?
I have not. No, I have not.
So a lot of what you're arguing in this bill is a theoretical, not more of a practical thing that most litigators see, but a theoretical thing that you probably learned through law school, but you've never actually practiced with and used.
Well, I'm relying on the opinion of a Supreme Court justice who has a little bit more experience than probably anybody in this room on it. So
Well, I know Justice Victory. I know him very well. I'm just asking that this presumption is not something that it's a long-standing presumption within litigation circles, and there's probably only a handful of litigators in this room that really know what it does on a practical experience. I just wanted to make sure that I wanted to ask you if you had ever had the opportunity to use it in any of your trials before. I didn't realize that you had never practiced before. So I'm kind of wondering, I feel like when you shift the burden like this, the Louisiana Law Institute usually kind of weighs in on those things. Did you ask the Louisiana Law Institute what their position was on this particular thing?
Well, I did not. I don't think this is that. I mean, it's not that complex of a movement. It's really a court-created law. I mean, it's a court-created law that it can be undone. It can be done by the legislature. It wasn't the will of the legislature to enact this to begin with. This was as Justice Victory points out, it was basically a mistake by the court to interpret it outside of the workers' compensation. So, I mean, I don't think the Law Institute needs to weigh into it. If you look at my bill, it's one sentence. It's not, like Representative Miller's bill that was, completely refunding or changing the trust code that was 17 pages long. It's a single sentence that gets rid of this presumption. So
just because it's a single sentence doesn't mean it's not going to have massive ramifications to our legal institution.
I mean,
what I'm asking is that I guess the answer is no, you did not ask the Louisiana Law Institute to weigh in or opine on this matter before you brought this bill, correct?
Yes, that's what I said, no.
Okay. Thank you.
Representative Marcel for a question.
So.
Thank you. Representative Nelson.
Yes, ma'am.
So you're seeking to eliminate the presumption of causation established only in a personal injury case, is that correct?
Yeah, it's exactly only in personal injury cases, because that's where the court has interpreted this to go. It's not beyond that.
Okay. And so what made you bring this bill?
What makes me bring this bill?
Right.
I can tell you.
Typically,
you mean did a lobbyist give it to me or anything like that?
No. Well, what I'm getting ready to ask you is, when we bring bills, it's because something has happened, did you know, that caused us to fix something that is broken.
Yes. No,
right?
I can answer.
Did you know?
Yes. So when I used to live in Northern Virginia when I worked for the Foreign Service of the State Department. When I moved from Northern Virginia back home to Mandeville, Louisiana, I had the same insurance carrier, USAA. I had the same car. I had the same drivers, my wife and I. And the only thing that changed in the policy was my address. It changed from Virginia to Louisiana. And when that happened, I called USAA and I told them I needed to switch my address. And they said, "Congratulations, Mr. Nelson. Welcome home. Your insurance is now doubled." And I thought it was a mistake. I thought, hey, you guys must be charging me for a year instead of 6 months. And they said, no, that's the cost of living in Louisiana. And I'll be honest with you, before that, I had no idea about any of this stuff. And that was before I ran for office. And so when I said, well, why is that the case? I'm an engineer, I'm an attorney, I should be able to figure out why. And I looked at all the reasons that were why. And a lot of them are addressed in the omnibus bill that we'll hear later and we'll hear another day, but not all of them are. And that's why I brought this bill, is because this is one thing where Louisiana stands out from every other state, including Virginia. And I said, well, this is a problem, and this is probably a cause of why those costs are so high. And so I'm fighting to keep the people of Louisiana have lower insurance rates, because it hurts all of us.
So you believe that shifting the burden to the plaintiffs on an injury is going to save us on our insurance, is that correct?
Well, yeah, I think Judge Carter said it best, where you said you have a plaintiff that has absolutely no objective evidence. And you say, well, they have absolutely no objective evidence, and they are entitled to a presumption that the injury they're claiming exists against a defendant who is just as innocent, who might be just as innocent as anyone else. We don't know that. That's why the burden is on the plaintiff to prove their case. And that's where we're trying to put it.
And has any insurance company told you, Representative, that if this bill passes, that they will reduce our insurance premiums? Has anyone told you that?
No, they have not. No, they have not. No, they have not.
Have you spoken to any judges or lawyers that perhaps have practiced and have had trials, and have you had those conversations?
I have. Actually, I filed this bill, and when people read it, I had a lot of people contact me from all over the state that says this is a great idea. I wish I would have thought of this before. I think this is a very, very, pertinent reason about why we have such high insurance rates in Louisiana, and I'm so glad you're bringing this legislation.
I would love to do something to decrease our insurance premiums. However,
You
I
can
think
vote right now.
You have to have, you need more stats to prove to me, and some commitment from the insurance companies that would happen with this. I don't believe, did you know, that changing the burden of proof to the plaintiffs will achieve that goal, did you know? And so I'm just a little confused of, if you've not practiced, you've not been in a courtroom, why would you not speak with perhaps people that have,
I said I had spoken to lots of people that
like your colleague in the
have.
back, Mr. Lacombe. But thank you very much.
Yeah, no, I have spoken to lots of people who have practiced, and they are all in support of this. So, and thank you.
Members, I'm all about good debate, but let's make sure we keep questions and not just opinions. So next is Representative Ivey. Question on the bill?
Yes, Mr. Speaker. So I'm not an attorney, but this seems pretty straightforward. I thought maybe there was something more complicated out there, but it seems pretty straightforward. You've done a good job presenting it, and now I'll get to the question. If I don't have a medical history that shows I've had any back problems, would that be sufficient in a trial to say, look, I've got no medical history with back pain, and of course I'm having significant back pain? Would that be enough, the fact that I don't have a medical history with back pain?
Are you saying with the presumption or without the presumption?
Without the presumption, we have to prove it.
So without the presumption, you present that evidence, and you just have to meet the burden
So
of proof.
the absence of a medical history
Yeah,
is
that definitely
the
supports.
evidence.
Yeah, that definitely
that-
supports it in either instance. Yeah,
Right.
definitely supports it in either instance.
All right. And you mentioned something. This is clarifying an interpretation of a ruling or something like that? Or
No,
we're not
so this is-
changing law here. We're just
So yes, we're
clarifying.
changing what the court has interpreted. So the court,
What the court has
the court
interpreted.
created this law. The legislature did not. And what this is doing is saying this is the will of the people of Louisiana and the legislature, that this court-created rule should not apply any longer.
Right, because I'm seeing just words being added. There's nothing being subtracted.
Yeah, it doesn't exist currently.
Okay. Thank you.
All right, thank you. Representative Gaines for a question.
Yeah, Representative. Normally, when someone wants to change a structure, or change a practice, or change a procedure, usually there's some experience with that procedure to be able to identify what's the best practice. Given the fact, you said you have not practiced before,
I have not.
and is there any reason why you feel that this would be more effective in terms of protecting our citizens if you haven't actually experienced what goes in a courtroom and what types of evidence deems to be the best evidence to afford a person justice?
Well, I mean, I think that just because you bring a bill doesn't, just because, Philip de Villiers has never drilled an oil well doesn't mean he can't bring a bill about oil.
It certainly gives him a better perspective, doesn't it?
I mean, I think if I can be an unbiased outsider who looks at the situation and comes to a conclusion and then speaks with people who are very knowledgeable of it, including Supreme Court justices, and from that come to a conclusion that's going to benefit the people of
So
Louisiana.
what's your definition of objective evidence in terms of an injury case?
I mean, I trust judges, I trust juries.
No.
I think it's up to them to
What's
say
your
what objective
definition?
evidence-
Not the.
My bill doesn't include the word objective evidence. It doesn't make any reference to that.
So how does your bill define what's necessary to prove an injury? Or how do you define what's necessary to prove injury?
Well, it just reverts to the default law. So the default law says the trier of fact shall hear the evidence, and that's what it is.
No, I'm asking you, how do you define what's necessary to prove an injury?
I mean, I think it's not beyond a reasonable doubt, preponderance of the evidence, just like it is for the standard of all civil cases, for all civil facts. That's what it is. So the plaintiff has to prove it, just like they have to prove every other element of their case.
Well, I was asking a physiological question as opposed to a legal terminology question.
I mean, I don't know what you're. I mean, what?
Okay,
I don't understand. Sorry.
So As far as the, let me ask you this: the courts, you do know that that this is a long-standing. This was established by a long line of legal precedents that was determined by judges and judges for years and years all over the state. Correct?
That's correct.
And you want to legislatively overturn that with one bill.
Yeah, so I don't believe the judges should really be creating the law.
Oh, really?
I think the judges should, yes, I think that in this case, the judges created the law. I think they impermissibly shifted the burden of proof to the defendants,
the judges,
and that's the problem.
The judges interpreted the law as it would best apply to afford justice. That's exactly why we have this precedent. But thank you.
Thank
Appreciate
you. All right, I'll wait for further questions, Mr. Speaker. I could do this all night, but these people have a Memorial Day holiday they got to get to. So.
All right. Representative Nelson waives the questions. There was 4 questions in the queue. Representative Wilford Carter would like the floor on the bill.
Okay.